Thank you, counsel. Mr. Joshi?
Mr. Chief Justice, and may it please the Court, we agree with petitioners that duty and authority is the right way to figure out in what capacity a public employee defendant is acting, but we think the Court should focus on the subset of cases involving a denial of access to property. In those cases, if the defendant is exercising an official duty to provide access, like hosting an official school board meeting, of course that's state action. It doesn't matter where it happens. But for other kinds of duties, and most important, where it's ambiguous, where it's the kind of thing a private citizen could do, but also within a broad description of the official's responsibilities, there we think the nature of the property should be all but dispositive. So if the defendant denies access to government property, probably state action. If the defendant denies access to her own personal property, she's probably acting in her capacity as a private property owner, not as an agent of the state. And that framework, especially insofar as it provides a default rule for hard cases, we think is more consistent with the purposes of the state action doctrine, will resolve these cases today and others like them, and will avoid the need for this Court to set forth a one-size-fits-all broader duty and authority test of broader applicability. Welcome the Court's questions, but happy to talk about.
What exactly is the property? The contract talks about terms of services, I guess. I'm not a Facebook person, but I assume they would not consider the service property. So what exactly is the property?
Well, I think the property, it's a form of virtual property, but it is the account. You can post speech on there. You can have conversations on there. You can open it up to everyone or just to friends. It is a form of virtual property. It's like a virtual, I hate to use the word forum because that term is sort of overloaded in this context, but it's a virtual forum of sorts. It's no different from, say, a hotel that offers its ballrooms for rent to people, and you might sign a contract and have terms of service. But when you take that hotel, you have a certain degree of control. You have one of the sticks in the bundle of property sticks, and you can choose who gets invited, what you do there. This is just a virtual space of the same sort.
So would you just follow up? Do you think that you have to take into consideration the role of the provider of Facebook too, since they can also evict you from this room that you're in or this account?
Yeah, so not in these cases, and I agree that there are some really difficult questions as to the extent of ownership and control over this virtual property as between Facebook and Twitter and petitioners in this case. But what should be undisputed and is undisputed is that the Poway Unified School District has absolutely no ownership or control over these pages, and that's the relevant question for the state action question in these cases.
What if, excuse me, what if something that looks an awful lot like an official event, but is not labeled as such, is held on private property?
I think the question in these cases is the constitutional one of state action. This Court has often said the Constitution deals with substance, not shadows. And I think these sorts of appearances are the kind of shadows that shouldn't matter to the substantive question of whether, to use petitioner's test, it is an actual official duty and authority being exercised on that property. And I think this Court has rejected to the extent Your Honor is invoking reasonable observer kind of test, this Court has rejected it in a variety of contexts, most recently in the Coach Kennedy case. I mean, I think maybe to a reasonable observer, a lot of people would have thought that that coach was acting in his official capacity, but the Court didn't rely on reasonable observers, at least as it saw the facts. It said, we're going to delve into the facts and figure out exactly.
Let's say in a small town, the population is bitterly divided over an issue. Let's say it's whether they're going to close down their elementary school and send the children to another school 25 miles away to save money. And the mayor is in favor of closing down the school. So the mayor holds a meeting on public property, and everybody can go and express their views. And after that meeting, the mayor says, well, that didn't go well. There was an awful lot of opposition expressed to this. Let's have another meeting. And this time we're going to have it on my farm, and I'm going to post people at the entrance, and we're going to exclude the people who spoke vociferously and articulately against my proposal. Is that allowed?
So if I understand
And the mayor's not running for re-election. He's term limited, so this is not a campaign of...
So if I understand it, and if I can assume that when he does it on his farm, he's not using any government resources,
right.
The security guards are paid out of his own pocket,
right.
Totally fine, I think. Again, and then let me further assume that the vote of the people on this farm meeting is not somehow like conclusive. They don't actually have the authority. He's just taking their views into account. It's no different than elected officials anywhere or government officials anywhere who choose to speak only to Republicans or only to Democrats in order to get views on what they ought to do when they exercise their official duties. No one thinks that that's state action. And I understand you can think of a lot of odious behavior by government officials being discriminatory in whom they speak to and whom they listen to. But at the end of the day, the Constitution does not prohibit even odious behavior by private citizens. And I want to return here now to a point that Mr. Mupan said, which I really do think is maybe one of the most important points in this case, which is that a lot of the scare hypotheticals that the other side gives about public officials behaving badly, if you narrow the state action doctrine, can be taken care of by their government employers or by the state through statutes. The government as employer has much greater leeway to regulate than government as sovereign. And so this court has decided a number of cases in which government employees acting in their private capacities can nevertheless be regulated by their employers. And so if you're worried that there's not a code of conduct for government officials and how they comport themselves in their personal private capacities, such a code of conduct is better if it comes from the government